Hello, my name is Melissa Rogers, and I'm the Vice President of Business Development for Heritage Property Management Services. And for those of you who have joined us in the past, you might remember our friendly face that's going to be joining us tonight. But we are going to be joined by Lueder, Larkin Hunter's very own attorney, Cynthia Hodge, as she reviews part one of a part or two-part series where we're going to be covering topics related to fair housing and how it applies to your community association. So tonight's part one is going to get started here in just a second. But before we get started, I just wanted to gently go over some of the technology rules as it relates to asking questions. So Cynthia does have a very action-packed class. We're probably going to be looking at least 50 minutes of education, but we are going to carve out some time at the very end for your question and answer session. So feel free to go ahead and submit your questions in the upper right-hand corner, which we believe is where that question is going to be located for you, or that Q&A button is going to be located for you. Feel free to go ahead and submit your questions through there. We will be looking at them throughout the presentation, but Cynthia is going to hold the answers until her presentation has been finished. So without further ado, I introduce you to Cynthia. Thank you so much for joining us tonight.
Thank you so much, Melissa. Good evening, everyone. Thank you so much for joining us, and we hope that you will continue to stay with us tonight as well as next month. And let me make sure I have this perfect. So my name is Cynthia Hodge. As Melissa said, I am a partner at Lueder, Larkin Hunter. I've been there almost 16 years. And I want to give a big thanks to Melissa, to Josh, to Kate, to Megan, and all the team at Heritage for inviting me as a guest presenter tonight. All of their organization and behind the scenes to get us to this point. I think 2025 is going to be a wonderful year, and I hope you get to take advantage of many of their courses throughout the year and the guest presenters that are going to come. I am going to be here tonight and next month to cover FHA. So let me go ahead and break down what we intend to cover for tonight, which is the fundamentals, I guess is the best way I can put it. I'm going to go over the fundamentals, FHA's impact on community associations, a little brief history. We're going to go over how insurance plays a role as well. Then we're going to resume on February 20th, so please register and save the date. We'd love to have you. And we're going to go over how to avoid costly FHA discrimination claims, as well as how to navigate challenging homeowner disputes. And the reason that I want to break those up is because we have a lot of great real life scenarios, case studies that we can talk about, how to give you the tools to help you navigate those issues, especially with some of the more recent rules that HUD has put in place, including the quid pro quo and anti-harassment rule as of 2016. So really want to make sure I focus on those issues in the second seminar, and I hope you're able to join us for both. Now, again, tonight's topics, I'm going to review the protected classes and definitions. Brief history lesson. I am no historian and I'm no politician, so I'm not going to go into a lot of details, but I am going to go cover a brief snippet of that. I'm going to cover reasonable accommodations and modifications. That's actually a really great tool to avoid discrimination claims when we have these requests, how to respond to them. So I really want to make sure that I cover that with you all. I'm going to cover service animals and emotional support animals because when they are valid, they are not considered pets. And we want to go over that and what that sort of request looks like as well. And lastly, I do want to touch upon insurance, how it plays a role. And I'd love to give you, as homeowner leaders, some tips and recommendations as you may be nearing a renewal of your insurance to make sure you know what's in your policies and make sure you're adequately covered for discrimination cases and fair housing cases. I hope that sounds good to everybody. So let's begin. Now, I have to go from the very basic fundamental, which is what kind of laws are we talking about? In Georgia, we actually have kind of three sets of statutes that all promote fair housing. We obviously have to rely upon the federal laws that are in place. The Federal Fair Housing Act that prohibits discrimination in housing based upon our protected classes. I'm going to define all of the protected classes in just a minute, so I will go over all of those in detail. But Georgia decided that the Federal Fair Housing Act looks pretty good, and we copied and pasted, and we have our own set of statutes that mirror the Federal Fair Housing Act. And so we have state law that prohibits discrimination in housing based on the protected classes. So if you violate one, you're violating both. And I'm going to take it one step further for any of the homeowner leaders that might be involved in real estate. Perhaps you're a broker as well. Perhaps you're a CAM. Perhaps you have your salesperson license. You are also governed by the licensing law that also promotes fair housing. And this is a body of statutes that govern real estate licensees and aims to protect the general public in real estate transactions. Now, why do I say all of this? Well, because the Fair Housing Act was actually originally adopted via this Title VIII of the Civil Rights Act of 1968. Why? Again, brief history lesson is there was gross inequality in the sense of real estate transactions and access that people had to them, especially those in protected classes. So these laws were put in place to help try to mitigate that. Is it a perfect system? No. Still to this day, we have issues with fair housing and discrimination, but these laws are in place to help to minimize those issues and to be able to help promote fair housing. Significantly, the Fair Housing Amendments Act of 1988 is another amendment to fair housing that I just want to highlight and mention. And the reason I highlight it is that it actually established a role of the Department of Housing and Urban Development's secretary, and that secretary can adopt additional rules. And we're going to talk about in February that specific rule about anti-harassment that was put in place in 2016. So this amendment itself was relevant to that. But for all intents and purposes, it's kind of hard to talk about Title VIII and Fair Housing Amendments Act. So we're just going to say Fair Housing Act for the rest of the presentation. And the Fair Housing Act prohibits discrimination in any respect against people in protected classes regarding the following things, right? It's the sale, rental, or financing of dwellings. It's the provision of services and facilities connected to those sales or rentals. Any activities related to sale or rental of dwellings, the availability of residential real estate transactions, and what's most important for our homeowner leaders and for people like me who work with homeowner leaders is it's the provision of services and facilities in connection with residential real estate. That's that catch-all provision that kind of covers how associations will operate. Now, I point out and say that the reason that these laws were put in place was to promote fair housing, and it was to protect the general public in real estate transactions because, generally speaking, many people are not as familiar or educated on real estate transactions, so they can be taken advantage of. So there's a reason why these laws were put in place and have been amended over time. Most recently, however, and I do like to give statistics now and again because I was a math person, and so I like numbers. But what I want to also point out is that we have not solved all of the issues. We know that. And in fact, in the last decade, we have started to see a different trend and a rise in discrimination cases as well. And those are related to hate crimes, which again, go towards protected classes. We've seen, as you can see from these statistics, and these were gathered not only from fair housing, but also from the fair housing sites, but also the FBI sites as well. There's been a continual increase over the last decade of increase in hate crimes. What is important to note is that 25% of hate crimes actually happen at or near someone's home. Now, the reason that I point this out is because we are homeowner leaders, right? We work with communities that have, for all intents and purposes, we have a duty to help promote the well-being, welfare of our overall community, to keep up standards, and to promote the properties in a certain way so that we get as much as we can for our investment. Because again, property values matter. This is one of our greatest investments. So associations have this very unique situation where we are here to help maintain property values, to maintain the overall neighborhood and community. And we know that there are things that are happening at or near other people's homes that can be discriminatory in nature. So it all, I want to say, it all comes together. Now, to summarize, it's illegal for landlords, sellers, mortgage companies, and homeowners associations to engage in discrimination of protected classes during the course of any housing-related transaction. Now, we know that the Fair Housing Act defines housing provider, and it expressly includes associations in that. Now, I put this little picture together to just mention that associations means any association that we have. We may have high-rise condominiums or mid-rise, low-rise condos, standalone townhomes, row townhomes, single-family homes, office parks, multi-use communities with commercial and residential. All of them are considered associations that are defined within the housing provider definition. So it's all going to be part of it. We're all subject to the Fair Housing Act. And just to summarize that further, courts have applied the Fair Housing Act to all of these entities. And as you can see, condos, homeowner, townhome, property owners associations are all part of that. So what can we not do? We can't discriminate against a person in a protected class in the provision of services or facilities, and that includes the dwelling, the unit, the common areas, the common elements. And we also can't make, print, or publish any notice, statement, or advertisement that can include rules, that can include the declaration, the bylaws, etc., that indicates any sort of preference, limitation, or discrimination of any person in a protected class. So on paper and in practice, the rules have to be facially neutral and no disparate impact. You could jokingly tell me that that sounds very legal. I don't understand that. So I will summarize it just briefly, because you're right. And you don't need to know that. That is a legal term. But what I'm meaning is that a rule has to be facially neutral, meaning it does not call out any specific group or any member of a protected class in the rule itself, in writing. And even if it doesn't call anyone out, the actual application of that rule can't actually have a disparate impact. Let me give a quick example just to help illustrate that. We all probably know that we, the association, the board, we can't evaluate tenants and determine which tenants can come into the properties for our owners, right? We know that that's not an okay process. But let's suppose that we did want to put in a rule into effect. And I will say this, about 10 days ago, so beginning of this year, I can honestly say I had a client who asked me this question. They wanted to put in rules. They didn't realize this, and it's not effective yet, but they asked if they could be more involved in the tenant approval process and have these rules that say they must have an income of $150,000 or more. They have to produce their W-2s from the last year. They have to provide a criminal background check for the board to review and inspect, as well as a credit report. And they wanted them to sign an affidavit that they had accepted the rules, acknowledged the rules, etc. And I had to explain to them, somewhat, not harshly in any way, but I had to say, you know what? All but that affidavit has to go, because we, the association, cannot be involved in the tenant approval process. We are not responsible for determining who can or cannot, because it's going to create FHA issues. And so I had to tell them that that sort of rule would not be enforceable. It would be an FHA violation. And rather, what we can do is put the requirement on the owner to produce those reports. And let me clarify, not to produce the reports, but to pull the reports and provide receipts that they did it. We don't want to see the reports, but we want to be able to know that they actually did it. So there are ways that we can incorporate certain requirements, but we, the association, are not going to be governing who can and who cannot, because there could be FHA ramifications to that. Now, I know that I'm in the virtual world and that you can't answer my questions, but let me ask the question, what's the exception to this rule? When can an association discriminate? That sounds awful to say. I don't like saying it really, but when can an association have practices that are discriminatory in nature? And the answer for any of you who are in this category is age restriction associations. So an age restriction association does not discriminate based on color or national origin or race or disability, but it does discriminate against familial status. And the Fair Housing Act expressly carves out this requirement and allows for this to happen. And these associations can be formed as condos, they can be formed as mandatory POAs or mandatory HOAs. And the retirement community, or better known as the Age Restriction Association, has to meet one of two conditions. Either 100% of the community is 62 or older, or 80% of the occupied units are occupied by at least one person who is 55 years of age or older. Now, for those communities that do fall within those parameters and have those requirements in their governing documents, they have to maintain accurate and constant records to make sure that they do qualify to be able to stay in that category, and as such, be able to discriminate based on familial status. Now, very briefly, we're going to go into all the definitions of the protected classes, but just so you know, when I teach, I have to make sure I can give them something that they can memorize. I use fresh corn minus the vowels as the mnemonic device, but the 7 protected classes we have are familial status, religion, sex, handicap or disability, color, race, and national origin. For my visual learners, I have this little diagram that can help show and illustrate the exact same thing. We're going to go into the definitions of each and every one. And we're going to end with disability because disability is actually the most complicated of the definitions, just under the Fair Housing Act. And it leads us right into reasonable accommodations and modifications because, again, those requests are only disability related. So, but before we do that, I'd like to show a little bit more statistics. I mentioned that housing discrimination cases are on the rise, but it helps me to be able to support that by actually showing you true evidence that you can find online as well. So if you go, and I'll show this in a few slides, the National Fair Housing Alliance has created trend reports starting in 2023. It's first ever that they ever did this, where it's nationwide. You can look at any state and determine how many complaints have been filed and the breakdown of those complaints based on the protected class. Now, it doesn't give the end results. It doesn't say which ones have been resolved, which ones are found. It doesn't have that data, but it does show the number of complaints filed on an annual basis and how it breaks down per protected class. So 2023 relied on 2022 data, and that report showed that there were over 33,000 complaints filed in the United States in 2022. And it was a marked increase of almost 6% higher than 2021 and almost 6% higher than in 2018. So over the last decade, and especially since 2018, we're seeing marked increases in our housing discrimination complaints throughout the country. Discrimination based on disability. So disability complaints make up the majority throughout the country. It's over 53% of the complaints that are filed. And 2,490 complaints were based on sex. Now, fast forward one more further year. So in 2024, about August, September of 2024, the 2023 report was published. And so this is the results of that, and I'm just summarizing it here. So the housing discrimination cases rising in 2023, we actually saw the largest amount of complaints ever filed, of 34,150 complaints in 2023. Again, disability complaints and disability complaints on discrimination accounted for the majority, over 52% of complaints filed. 1,521 complaints of harassment were reported in 2023, which was an increase of 66.23%. And there were 824 complaints based on color reported, which was an increase of 35.3%. As I mentioned, if you go to the National Fair Housing Alliance, you can pull up, or you can search for that and search for trends report, and you can pull these reports. Again, there's only 2 in existence right now, but I find it to be very useful and interesting information. I obviously clicked on the map and went to Georgia just so you could see what it looks like. And for 2023 data, it was 300 complaints. And as you can see, disability was the overwhelming complaint that was filed. And then following that was race, and then national origin and sex were kind of tied for third. So just so you could see a picture of what sort of complaints are being filed. Now, this is across the board for all housing providers. This is not just for associations. But I do like to be able to see that, again, disability tends to be what is complained of most. And that's going to be really important for what we talk about tonight, because we're talking about reasonable accommodations and modification requests. And if we, the association, do not respond timely, we get in trouble. So I want to make sure that your communities do not have that problem. So very quickly, let's go ahead and define the protected classes. Now I'm going to go over the first 6. And then we'll do disability. So race refers to any person who is white, Black, African American, Asian, and I apologize, I can't see my little, hold on, let me see if I can push this down. There we go. It refers to a person, I'm going to push this down just a moment so I can see. It refers to a person that is either white, Black, or African American, Asian, American Indian, or Alaska Native, or is Native Hawaiian or Pacific Islander. Color refers to the visible color of a person's skin. That is, whether a person's skin is light or dark. National origin refers to birthplace, ethnicity, ancestry, culture, and language. Religion refers to the practice or non-practice of religion, such as atheism, as well as religions that are not mainstream. Sex will include biological gender, gender identity, and sexual orientation. And familial status includes the presence of at least one child under 18, pregnant women, or people in the process of adopting a child. Now, I use this slide here just as a good transition for a case that is a very prominent case in our community association world, and one that I'm going to share with you today. And the reason that I share it is because it really took familial status and made it prominent for these types of fair housing cases. Let me be clear, Fair Housing Act does not distinguish between any of the 7 protected classes. There is no one protected class that is more worthy of protection than anything else. They are all equal, they're all even. But in the past, before this case that comes out in 2004, familial status wasn't really litigated, it really wasn't pursued. And interestingly enough, the case that comes up it actually involves an association in California. So the little picture here shows a clubhouse, and it shows a mother with their child, and it says, in order to preserve the beauty of the community, no kids are allowed. So it kind of leads me into this Keys condominium case. So the Landsman case is a very prominent case, came out over 20 years ago in 2004. And as you might mention, or you might be able to see, is that it's actually a California case. It's not in Georgia, but because we deal with the Federal Fair Housing Act, we look at all cases because of the federal law. What the Keys condominium decided to do was to say, we want to have a pool that's nice and quiet and has adults only, and we don't want kids because kids are loud and noisy and messy and they just disrupt everything, and we don't want that. So they created a rule that basically said no children are allowed. It's an adult-only pool. And that in and of itself, as the court found out and explained, was that is a direct violation of the FHA. You cannot have adult-only amenities in associations. By contrast, this community also had several rules regarding their clubhouse and their gym, and they had certain restrictions of which ages of children who could or could not use it. And the courts at that time found that for some of those rules, they were applicable because of safety reasons. So they were allowed, others were a violation of FHA. Now, the reason that I bring this up is not to quote all of this and read it to you, but I do want to highlight it. The reason this case is so important is because it put familial status at the center of a particular case that it had not been before. And familial status, as the court says, is just as important. You know, the access by children is just as important as restricting access to women or people born in Iraq or China or members of the Episcopal Church, as they used in their example. That would be equally unlawful to do. So in this situation, what the court was saying is that there is no exception to the scope of protection such that discriminatory treatment based on familial status would be acceptable under the FHA. If there is a showing that adult residents of a housing complex don't like sharing a swimming pool with children, you can't create a rule just because of that. So adult only, we know, not allowed. Now, that case is 20 years old. And so over the course of these 20 years, we know that other cases have come out trying to also establish what is acceptable and what's not acceptable under the FHA. There's been rules about 16 and under not allowed, 14 and under not allowed, without adult supervision. They're not allowed to be at the pool. And ultimately what we have found is 16 under and 14 under are still violations of FHA based on case law. So what I want to recommend to those who are with us tonight And for any who listen to this afterwards, generally speaking, it is safe to prohibit children 12 and under from swimming without adult supervision. That rule itself is acceptable. Anything outside of that, what it does is it opens you up to liability because it could create an FHA case down the road. Now, it doesn't mean that anyone will, it just opens you up to that. Now, what's great about this being January is that most people are not in the pool. I mean, if you remember, about a week ago, we had snow on the ground, which is not very common here in Georgia. So our pools are not open, and this is an excellent opportunity if you have not reviewed your rules and regs in a while to review them. Make it a priority. Make it one of your agenda items this first or second quarter and see if this might be something we have to update. Maybe the pool rules that are posted at your pool might say something that is not consistent with this. And you want to update that before next year's, before the upcoming pool season. This is an excellent opportunity to review these rules. I want to highlight one other thing because we talk about adult only a lot. I do know that there are communities that have like the 15-minute adult only rule when the lifeguard steps away. I know that there are communities that also try to say, well, they have multiple pools, so they want to make a pool that's adult only. Again, what I want to point out is that those are all still violations of FHA. Now, you can accept that risk and proceed, and that's okay. But I do want to make you aware that based on the case law, these are still violations of FHA. All pools should be able to be accessed by anyone, provided that you have this particular rule of a 12 and under without adult supervision is being acceptable. I have also suggested this to other clients about the lifeguard stepping away and having it be adult only. Rather than it saying adult only, what you can do is to say that anyone who can swim the length of the pool is able to be in the pool, right? So now you're not creating a familial status discrimination. It's anyone who's able to swim the length. And that could be someone who is 12, that could be someone who is 10, and that is someone who's 15. That's acceptable. And you're not really running afoul of the Fair Housing Act. So these are just some, I say, tips or recommendations, but I do want to suggest that if you have an opportunity and you have not looked at your rules in 5 or more years, this might be a great opportunity to do that. Now, we've gone over 6 of the 7 protected classes. Disability is obviously the most complicated of the definitions. It has the most involved with it. And basically, it's defined as an individual with a physical or mental impairment that substantially limits one or more major life activities. And that's somebody who is regarded as having it and they have record of it. So let's go into more definition. Physical or mental impairment can include any of these diseases and impairments, but this is not an exhaustive list. This is just an example. What I want to point out to you as well is that for many of these examples, they're not always obvious and known. And that's going to factor into our reasonable accommodation modification discussion because we realize that we may not know that someone has diabetes or that someone may have cancer, and they may have to provide additional documentation to us to help us understand and know that they do have a disability within the FHA. Now, the term substantially limits also includes that the limitation is significant or to a large degree. And the term major life activity means those activities that are of central importance to our daily life. That's seeing, hearing, walking, breathing, learning, eating, all of those. Again, not an exhaustive list, but just gives you an idea of what the FHA includes in its definition. So we're an association, we're a housing provider, the FHA always applies. Now we're going to go into reasonable accommodations and modifications. These are the day-to-day type of things that get asked. This can be, and I'll give examples, but this is going to be anywhere from the emotional support animal request to someone needing a parking space moved. This could be a modification to someone's dwelling to extend the driveway so that they can use their walker or wheelchair to get easier access to their home. These are all typical requests that can take place. Per federal law, I do want to stress and point out that we have to keep all requests confidential. meaning they do not get discussed later on after they've been resolved. They do not get discussed at open meetings or annual meetings. They do not get discussed with board members, spouses, or anyone else. It should be maintained by the board and any of their agents, the managing agent, your legal professional, etc. But these types of requests must be kept confidential. Now, under the FHA, a reasonable accommodation is a change, exception, or adjustment to any sort of rule, policy, practice, or service that is necessary for a person with disabilities to have equal opportunity to use and enjoy the dwelling. And that it can include the facilities, right? Your common amenities, etc. So a reasonable accommodation, to summarize, is just basically you're asking for a change in a rule or service or an exception to something. Easy examples that I can give that I may have mentioned before is, let's say you have to request a parking space that is closer to your unit because of your disability. You may have a request for an emotional support animal or service animal that might be on a breed restriction list, but they are needed and you are asking for that. That would be a reasonable accommodation request. I've had a condo where their mailbox, they have a room specifically for mail for their unit owners, and they needed to modify the location of one to make it more accessible to one of their owners because of their disability. These are just examples of what a reasonable accommodation request could be. And if we fail to respond timely, and I'll talk about what that looks like, that person could believe that their request has been denied and they could file one of those complaints based on disability, right? One of those complaints that we were talking about. And if they did, they have to prove that they have a disability, that the association knew or should have known of their disability, that a reasonable accommodation was necessary, and we failed to provide it. Now, one recommendation that I would make to those who are in attendance today and for all of the boards that I work with is that when we get a request, it must be expeditiously handled. That's the word I always like to use, is expeditious. The Fair Housing Act does not give us specific timeframes, but they do make kind of general recommendations that, a 10-day time frame is reasonable, a 30-day time frame is not reasonable. So what we want to do is, if we get a request, that we want to take action as quickly as we can to schedule a meeting with that person, to move things forward in smaller increments rather than waiting a month or two to respond, because that is going to be looked at as an unreasonable delay, and it's going to look at it as a denial, and we're going to get in trouble, and we don't want that. And we have to remind ourselves that rules that are in place may have a different effect on someone with disabilities, and it could treat them, if we try to treat them exactly the same, it could deny them equal opportunity to use and enjoy dwelling or the common use areas. So we want to make sure that we do respect the requests that are made and make sure that we try to handle them as expeditiously as possible. Now, one of the things that is required in the analysis is that the person making the request has to show that there is a relationship or a nexus between what they're asking for and their disability. For instance, we had a situation with a condo that had very limited parking spaces. And the unit owner in question, or the unit in question, they had 2 spaces. And they had 2 cars. So there was no issue with the location of the unit to their parking space. But one day they decide to go ahead and get a 3rd vehicle, a motorcycle, in fact. And when they got that motorcycle, they went ahead and submitted a request and said, we would like to have a parking space allocated for this. And it's because the person has diabetes and they need the parking space. Now, in that situation, the association actually had a pretty decent argument to deny that request because there was not a sufficient nexus or relationship between those two. We knew that they already had a parking space. We already knew that it was convenient for them. Buying that 3rd vehicle doesn't necessarily mean that they're guaranteed a parking space in that situation. As it turns out, just if you're curious to know what had happened, there was discussion further, and they did actually make an accommodation. Because it was a motorcycle, they did actually carve out one of the non-spaces and kind of realign the line so that a motorcycle could park there. But that was their choice to make. in that situation, there was an argument that there was not a sufficient nexus and it could have been denied. But I always want to ask, when someone asks, can we deny requests? The answer is yes, you absolutely can deny requests. Now, here's the reasons that you would deny it. One, you could prove that the person is not disabled. Now, let me be clear, and I'm speaking to you through this little camera. No association is going to want to make that argument, right? We're not going to try to challenge that someone is or is not disabled. So even though that is a condition for denial, that's probably not the argument we are going to hold our hats on. So just to point out, academically, I have to say it, but realistically, that's not the argument we're going to make. Can we deny a request because there is no nexus between the disability and the need? Absolutely. And in that situation, on a case-by-case basis, that may be the answer that we arrive at. And then lastly, we could say that the request is unreasonable. Now, I'm going to say what is unreasonable. I'm going to give a legal answer and say it depends. And it does. These are all on case-by-case basis. It's all going to be factored in for a number of things. I actually give you here some factors to assess on a case-by-case basis, right? But the Fair Housing Act says that we can deny a request if there is an undue financial and administrative burden on the association, or if it fundamentally alters the nature of your operations. Okay, that's the justification under the act, but that doesn't really give us a lot of tools. So here are some factors that we'd have to consider. If we believe that something is unreasonable, that we cannot do that, it's going to be based on maybe the cost of the accommodation just being too much, the financial resources, maybe the association does not have the resources to be able to do it. Maybe the benefits that the accommodation would actually provide is not significant. And maybe there's alternatives that are much more cost effective and still meet the needs of the requester. So there are lots of ways that we can look at something not being able to be exactly what they ask for, but coming up with a compromise that is in the best interest of everyone. And oftentimes, whenever I'm dealing with these, and I probably deal with 3 or 4 a year, I would say most often than not, it is usually that, yes, I would say probably one gets approved just because of the request being asked, but many times it's with alternatives. So it might be denied on what they're asking for, but we're able to come up with a really good alternative that is either less expensive, that we can combine funds, or we can wait for a period of time to be able to do the thing that we need to do. So again, association can deny and offer to make changes in a different way that would not pose a burden on the association and be able to meet the requester's disability needs. Just keep in mind that any agreement that we would ever have, that let's say it takes a little bit of time for us to get it accomplished, let's put it in writing, because we don't want that requester to come back and say they haven't done anything and it's been a really long time and I'm going to file the complaint, right? We don't want the complaints to be filed. That's what we're trying to avoid. So make sure that we put an agreement in writing or some sort of permanent format. Now, the big question is, what happens, can we ask pertinent questions where we're not violating the Fair Housing Act? And the answer is yes, of course. We're entitled to ask for certain information, but if the disability is obvious and the need is pretty readily apparent, meaning somebody has a service animal that, let's say it's a German Shepherd, and a German Shepherd is on your breed restriction list, and they have they're able to prove, as we're going to point out in just a moment, the service animal, and they are, I'm trying to think what I want to say. Oh, and they are blind, and the service animal is assisting them in that day-to-day activity, all their day-to-day activities. We really can't ask for any additional information. That's pretty obvious what their disability is and what they're asking for, so that we can make that determination. If the disability is obvious or otherwise known, but the need is not readily apparent, then we can actually ask for additional information. And if the disability is not obvious, what can we seek? And let me be clear, what we can ask for is we can request reliable information that is necessary to verify that they fall within the act, fall within the definition of disability. They describe the needed accommodation, and they show that nexus. They show the relationship between the disability and their need. Owners can sometimes provide proof, like if they have a supplemental security income or Social Security disability benefits, they can provide that. Let me go here real fast. An individual can provide third-party proof, which can include a doctor's note, peer support group, non-medical service agency, or a reliable third party who's in the position to know about the individual's disability. They can also provide verification of that. In most cases, though, just so you know, medical records or detailed information about someone's disability is not permitted, but they can provide a third-party proof. And typically that is usually like a therapeutic or medical provider. So to summarize, what we can ask is we can ask them for a third-party letter that says they're qualified under the FHA as under disability, that the accommodation is necessary to alleviate their symptoms, and that there is a nexus or connection between what they're asking for and why they are asking for in relation to their disability. Now that's reasonable accommodation. The other category is reasonable modifications, and this is a structural change made to existing premises. Now, I'll be honest, most times this is related to the person's unit or dwelling. If there is a need, let's say, for a change to the common areas, like a ramp to be installed to the clubhouse, or if there is a need for widening the doors or something along those lines, like to enter into the condo building or to a clubhouse building, that would probably fall more into a reasonable accommodation because it's falling within common areas. Reasonable modifications really pertain to the existing premises and allowing someone who has a disability to fully enjoy their premises by being able to have greater access to it. Easiest examples, the ones I get the most, are being able to build a ramp up to their home, extending or widening door frames if there's a specific door that you're supposed to use to ask for a modification of that, widening alongside their driveway to allow for walkers or wheelchairs to be able to have access to it. Those types of things are easy examples of a reasonable modification. And we're not allowed to refuse to permit them to make modifications so they can fully enjoy their property. So what we can do is we can require owners to submit plans and specifications. We can require owners to pay for reasonable modifications, and we can require owners to restore the property back to their original condition when the modification is no longer necessary. So in the situation of modifications, we're actually we can put the requirement to pay for it onto the owner itself. Accommodations are more things that the association will pay out of or partly pay out of, just so we know the difference. Now, let's shift to service animals and emotional support animals for a moment. These are reasonable accommodation requests, right? When someone is asking for a service animal or an emotional support animal, they're coming under the guise of reasonable accommodations. And just so you know, service animals are typically dogs. Just so you know, they're typically dogs. Back in 2011, 2012, they added miniature horses. But otherwise, other than those two categories, it can't be anything else. And these are dogs that are individually trained to perform tasks for people with disabilities. They must be under the control of their handler. These are some examples of service animals and what they can do. Again, it's not to provide comfort, it's actually to provide specific tasks to help with someone's major life activity. And that can be, again, guiding people who are blind, alerting people who are deaf, pulling wheelchairs, reminding someone to take medication that they need to take, etc. Now, interestingly enough, hopefully you know this, but if you don't, please know that there is no official organization that governs standards in the US regarding service animals. And there's not a requirement for service dog certifications, although there are places that you can get them. You are actually not even required to work with a trainer. Americans with Disabilities Act allows handlers to train their dogs on their own. There's no minimum requirement. There are private standards that suggest 120 hours over 6 months, but there's actually no minimum requirement provided in the Fair Housing Act or in the Americans with Disabilities Act. But dogs should wear relevant accessories so that they know that they are working, and you can take tests and register your dog and get IDs. The ones that I see that come across my desk, if there's a request for a service animal, usually they do have identification. Now, if the handler's disability is not readily apparent or known or obvious, you can ask, this is what the board can ask, is the dog a service animal because of a disability? And what work or task has the dog been trained to perform? You are allowed to ask that. That is within your rights to ask, and it does not get you into trouble. But the most common request that we get from a reasonable accommodation is the emotional support animal. And these are animals that have been prescribed by a licensed mental health care worker to offer emotional support. And anyone who falls or who has been diagnosed with a mental or emotional disorder will usually qualify for an emotional support animal. I've given a list here. This is not an exhaustive list. But if I mentioned before that we can ask for third-party proof, remember that emotional support animals, you must get it from a licensed mental health care worker. So it is not something that can be just from anyone. It does have to be almost like a prescription in that way. And emotional support animals can be any animal that does not violate your local zoning laws. I've had a situation as of last year, we did get it resolved in the association's favor. It related to chickens, ducks, and geese, specifically 30 of them. And they were trying to allege that some of them were emotional support animals. The way that we were able to get that resolved was twofold. One was that the emotional support letter was not actually for the owner. It was for a child that no longer lived in the home. And not only that, it was also the volume and that it was in violation of the local zoning law. So code enforcement was involved as well. But ultimately, as of this time, there are no longer any chickens, geese, or ducks at that particular dwelling. That was my latest one, was chickens. I have not had snakes. I have had rabbits, but there are certain requests that I have seen. Usually it tends to be more of like the dogs or cats, and specifically dogs that might be on a breed restriction for a community. Now, if you have a valid service animal or emotional support animal, they have the same rights, housing rights, right? They're allowed in pet-free housing. They're exempt from breed or weight restrictions. They're exempt from any sort of fees or rents or payments. Now, we know that there are owners who will go online and they will find a way to say that their animal is an emotional support animal, but we cannot always assume that they are lying when they seek to keep their pet and call it an emotional support animal. What can we ask? These are the safe questions. Number one, you can say, do you have a disability that substantially limits one or more major life activities? You can ask, can you provide the letter from a medical or therapeutic provider, right? They have to provide that. And three, we can ask, how does the animal provide support in reference to your disability? So we're not asking them to give details of their disability or anything along those lines. So we are safe and protected there. But we can ask these questions safely and effectively to be able to get information to make the decision on the reasonable accommodation request. Now, remember, if we have a valid service animal or emotional support animal, that does not give them carte blanche to be able to do whatever they want to do. They have to still comply with the covenants. They can't destroy common area or other people's property. They can't be able, you have to pick up their waste. They cannot create noise disturbances or be aggressive towards others. Giving you a real life example to that, we had a situation where there was an emotional support animal that was a Doberman that attacked another dog in the community. The covenants provided for the act of aggression to be something that could be, the dog could be removed. However, because it was an emotional support animal, that does create a problem there in terms of the removal. So what was agreed upon in that situation, it was a settlement, was that the owner agreed that the dog would reside in the home and in the backyard, and it would not be allowed out. If it ever was needed to be out, it would be muzzled at all times to protect anyone and everyone in the community, and that's how it got resolved. But keep in mind, if it's a valid service animal or emotional support animal, we may not be able to have them removed, as the covenants would say, if there was an act of aggression. And last but not least, I want to just touch upon insurance briefly. Again, I'm not an insurance professional. There are wonderful insurance professionals out there. I have worked alongside them. I've heard them give presentations similar to this, but I do want to rely upon what they have shared with me and when I've done presentations with them. When we get a discrimination complaint, we hope that never happens, but when we do, what do we need to do? And I did create like a little multiple choice question, but I'm going to give you the answer. But which policy do you file a claim like that? Is it the property insurance policy? Is it your general liability, your commercial general liability policy? Is it your directors and officers policy? Is it the cyber liability insurance policy that you have? Or is it the fidelity insurance policy? And the answer is your D&O. Your directors and officer policy is where you're going to file your HUD complaint, fair housing discrimination, etc. And interestingly, the D&O policy, just so you know, there's no Georgia law that requires us to have D&O coverage for associations. That makes no sense. Florida has something different, clearly. There should be a law, but there's not. However, all associations should have D&O coverage. Even if there's not a law that says you must, you should have it. It's considered third-party insurance because, in essence, the association is not the party who files. It's usually a third party who's filing the claim, right, against the association's policy. But the D&O protects the governing body of the association from this type of liability. And what's very important and what I want to highlight here for you, especially if you've recently, if you're recent and new to a board, if you've just had your annual meeting and you're a new board member, or if you've been on the board for a number of years, I want you to know when your policies renew. And if it's coming up, I want you to double check something for me. I want you to go and ask your carrier for D&O and say, what does our liability insurance cover? These three that are highlighted at the very bottom, discrimination cases, breach of contract, and fair housing, are typically not covered under general D&O. Like the standard D&O package does not include them. And it's not a significant cost to add and include. So what I want to do, because I'm talking about a fair housing and I'm talking about discrimination, I want to make sure that you double check. And before you have to renew, or when you renew, I want to make sure that you add those to your coverage if you don't already have it. If you already have it, great. But if you don't, it's recommended, and I want to make sure you know that, and it's not a significant cost to add. And that is from insurance professionals who have told me that. They recommend it, and I'm recommending it to you as well. Now, I've gotten to the point where I have finished kind of the lecture portion. I have a couple of quick slides just as a recap of what we've talked about, little tips and tricks. These are some questions I've come up with, but Melissa, I wanted to turn it to you to see if anyone has asked any specific questions in the chat.
Not presently, actually, because I think
Okay.
we're hitting them with so much great information. I would love for us to kind of go through.
Yeah, I have a
slide.
couple of questions that come up for my clients that they ask, and I thought I would share with you all and answer them for you, so that to kind of see if this will help. So my first question is, can the FHA apply when the ADA does not? I think a lot of times we get mixed up on our acronyms and whatnot. Remember, ADA is the Americans with Disabilities Act. And a lot of times we get confused and we say, okay, does that apply? Does that apply? Let me be clear. FHA always applies for our associations, right? We're always going to have fair housing governing us because we're housing providers in the Act. ADA does not apply unless we open our community up as a public accommodation. Fortunately, I would say probably, I don't have a percentage. I would just throw out a random percentage if that was the case, and I don't want to do that. But the vast majority of communities do not have to comply with ADA requirements because you are a community that is for the benefit of your members and their guests. You're not opening yourself up to the members of the public to come and go as they see fit. However, if you have amenities that do get opened up for, let's say, for rental offices in your clubhouse, or if you have a mixed use residential, you have mixed use and you might have commercial in a certain portion, and so your parking garage will have to be ADA compliant, those types of things. If you have a swim team and you have an active pool season where you have swim teams coming and going, your pool may need to be ADA compliant, and your facilities, tennis courts that have USTA or ALTA, again, you want to make sure those facilities are, because they will be open up to the public for a period of time, because those other teams coming in are not members or guests. However, I will say this, I do know that some communities can try to, because of the amount of people that are coming and going, sometimes they can kind of treat it as these are guests of the members. But again, for all intents and purposes, ADA is only going to apply when we are opening ourselves up as a public accommodation. And for the vast majority of our communities, we're not subject to that. So FHA always applies, ADA probably doesn't, but if you ever are in doubt, reach out to your managing agent, reach out to your legal counsel and ask them to confirm.
So before you go to question number 2,
yeah,
we actually did get some questions that I totally missed. So my apologies,
oh, okay,
friends
no,
in the
that's
audience.
fine.
But they're actually going to go right into kind of what 2 and 3 talk about. So I think the first one that we'll go to, this is talking about wheelchair bound individuals potentially. So what does it mean if a person who is wheelchair bound um, and they want to use the pool? This actually is probably more about the first
More
question.
towards the
My
question
apologies.
1 there.
Yeah, I was going to say, would the HOA have to install something for their use? And I think they're probably talking about maybe like a pool lift, like a chair lift,
the chair
or
lift,
like a
yes.
zero entry ramp. Sometimes we see zero entry at our pools, not just in the little splash pads, but sometimes I do see them in the larger style pools too. I think that that's probably what this person is potentially referencing. Great questions, by the way.
It is a great question. I know because my community has one as well, because we have 2 families that have they made that request. And so yes, what that would be is it would really be more of a reasonable accommodation, because and they'd have to make the request, right? It is something that they'd have to ask for. We don't automatically have to do that if it's not a public accommodation. But if they ask for that, then yes, the association would then have to consider that as a reasonable accommodation, determine if they have the funds for it, if they could work with the owner to be able to perhaps potentially partially fund it as well, because I know that they are costly. But it is invaluable. And I have seen those types of requests and those associations that have worked to get that to be installed. I know my community also has that, because we have 2 families that made those requests. But nevertheless, to answer the question is that, can they make a request? Yes. And yes, we would have to go through that confidential, expeditious review and determine if we can. Maybe we have to delay it a bit to save up for something like that if we don't have the resources. I don't know off the top of my head how much they cost, but yes, the analysis would have to come in if someone made that request. We don't automatically have to do it, but we certainly have to honor that request if it came in.
I remember when this was a really big topic many years ago, where, installing the pool lifts or the chair lifts was potentially very costly. And that big question of, well, are we required because it's our community pool? Because, the YMCA has one, so therefore our pool must have one. And this
right.
is
And again, if we're not
conversation.
opening ourselves up to as a public accommodation, there's not an ADA requirement for it, but from a fair housing, if they make that request, that's where it comes into play as that reasonable accommodation under the fair housing. But again, if they did make that request, we would certainly have to consider and determine if we have the funds, if we could approve it, or if we'd have to delay it and make arrangements for that. But that is something that can be considered.
Okay.
Was there another question?
Yes, as to say, this one is going to go into pool rules. And I'm actually surprised that we didn't get so many more questions.
I don't know if I just hit it home and they were just worried that they're not even going to look at it. I'm not sure, but I hope that they do.
Speaking from as a property manager, this is 100% the things that we see the most in pool season. It's not access control. It's not lifeguards, although that is probably the number 2 topic. It is making sure that our pool rules for our associations are airtight and having these kinds of conversations. So we reposted pool rules last year, and were advised by legal counsel that we could not prevent 14-year-old children from swimming alone, but that we could disallow children under 14. This seems to be in conflict with what you had mentioned earlier. So I'm wondering if the verbiage was possibly a little bit different in this. I don't know.
And I know it's hard to say without seeing the exact rule and thing. So I don't want to, summarily reject or accept it. But what I want to say is I certainly understand. What we have found is that the 14 and under rule across the country, there have been challenges to it. It has been found that it is suspicious. It does create an FHA violation. So the safest approach would be just the 12 and under rule. We do see, and believe me, I know I have clients. I have associations that still have the 14 and under language. It's just what it's doing is it's kind of opening up a little bit more risk. So I'm not saying that it's completely invalid. What I'm saying is that we're accepting a little bit more risk by keeping that language as is. But again, the 12 and under rule, what it's doing is it's basically minimizing to the point that there is no challenge to it. We know that there is no FHA violation if we have that language in there. So what I say to it, because I can't see the exact language, is that I do know communities that still have that 14 and under. They might have certain verbiage that's there. What we're doing is we're just kind of opening ourselves up a little bit more to liability. But keep in mind, it also has to be that someone makes that challenge. And there may be a situation that no challenge is ever made. So I'm not saying that it's automatically a lawsuit. I'm just saying that it opens ourselves up a little bit more to a lawsuit if someone were to really push that.
I agree. And thank you to the person that asked that question. That was a little bit very detailed in that particular portion of it. However, I agree with what Cindy is saying in the fact that I've managed several associations myself, and I have too seen that variance of 16, 15, 14, and 12 just really kind of hit that line. And again, to what she said, it just depends on whether or not you've ever been challenged and what the comfort level or the decision level is of all the parties that are involved, the correspondence. So thank you. Those were the two questions that we have. So I didn't know if you wanted to go ahead and finish the two that were on the slide that kind of go in with some of the things that we're talking about. And I fully anticipate that all of you that are in the audience now are going to join us in February as we do the second portion and really talk more about all of this fun stuff. But yes, pool rules.
Yes, pool rules, if you can update
of conversation. Oh boy, persons of incontinence. All of those fun things, those happen.
Yes, making sure it says no pets,
pool attire,
but service animals are allowed. Just keep in mind, emotional support animals still do not get a pass. They're not allowed to be at the pool. Sorry, that's not what they're for. But service animals are always allowed. So what we want to make sure with any pool rule change is that it says no pets, but service animals, and specifically that category is allowed. Obviously, they're permitted,
and that's because those animals, like you said, those animals perform specific tasks that are necessary.
They're specifically trained to perform tasks that affect and so one or more major life activities for that person. That's why they are allowed to be there, just like they're allowed to be at any public facility. Right? Sure. I mean, that's the thing. But emotional support animals do not get a pass on that. They're not allowed to be at the pool. So let me just touch on that because I do know that we're right at our time. Just so you know, if a tenant presents a reasonable accommodation or modification request, I get a very good question that's asked. So just, do we have an obligation to respond directly to the tenant? Oftentimes, the general rule for associations is that the membership is with the owner, right? The owner has the membership. They have the voting rights. They have the obligations. So that when we're dealing with typical requests, we're usually going through the owner first. I will say, though, this is the carved out exception, is that if it is a tenant who presents the disability and is asking for this request, I do not want us to ignore that. And so my recommendation always to associations is, yes, we do have an obligation to respond. My further recommendation is to also make sure that we're letting the owner know that we have received this request, because they could be, especially if it's a modification to their home, they're obviously going to have to be involved. But we don't necessarily just tell the tenant, no, we got to talk with the owner. We can talk with the tenant about reasonable accommodations and modification requests, because we obviously want to make sure we're expediting things and making sure that we're honoring these requests in a timely manner. So just so you know, oftentimes we just usually go through the owner, but for something like this, for the FHA, we do want to talk with the tenant. Lastly, do associations pay for reasonable modifications? Just as a review, for the reasonable modifications to someone's unit or home, no, we can require the owner to pay for those modifications. If they need to install a ramp or widen their driveway or things of that nature to help better their experience and enjoyment of their property, they are going to be responsible for providing the plans and paying for that. So lastly, these are just two slides, just as quick reminders. These are like a little recap tips for what you should do and take forward, what to put into practice. Just remember, for these requests, be expeditious. We want to meet and respond quickly. My recommendation is 10 days. I usually like to say 7 to 10 days. We want to be responding in some way, even if that's just to coordinate a meeting with the requester. We have to keep information confidential per federal law. We have to meet with the requester at least once. You're always going to need to talk with them in some way. This is not going to be something that's done just via email. You're going to need to conduct some sort of a meeting virtually or in person with the person requesting it. And we want to make sure that any decisions are in writing. So anything that's captured or any agreement of what we're going to do, we need to make sure that that's in writing. It protects us. It minimizes our liability exposure. And the last, what to put into practice, is just talking about rules again. Just make sure that you know what rulemaking authority you have. Update your rules every 5 years or so. If your rules say 2012, then you probably need to check those again and make sure that they're updated. Our recommendation is always every 5 years to look at them, make sure we see what's in there. And then, of course, for the amenities, recommending the rule to that children 12 years and younger must be accompanied by an adult to the pool. Recommend implementing any rules that mirror manufacturer guidelines on fitness equipment if you have a gym. That way you can rely on those recommendations rather than just kind of coming up with arbitrary rules for ages. You can actually say, here, this is the reasoning why I picked, why we picked this specific rule, saying that certain ages are not allowed to use certain equipment. Same thing goes for playground equipment. You could say the same rule and look at the manufacturer requirements for age and weight restrictions so that you, again, have something to rely on and you're not just coming up with something on the spot that could be challenged. And then lastly, try to avoid as much as you can adult-only activities because, again, it does tend to be an FHA violation. May never be challenged, but I just need you to know that it's in violation of FHA rules. So that's kind of my little quick summary. I want to thank everyone for attending. I wanted to make sure you know the next date is February 20th. That's when we're going to talk about harassment. We're going to talk about homeowner disputes. We're going to talk about more discrimination claims and what it looks like in practice and how we can further avoid them so that you have as much of a stress-free life as possible in your association.
We actually have a couple more questions that have trickled in, and
Sure.
I'm just going to ask just very briefly. And for those of you that can stay with us, we appreciate you. And if not, you'll be able to see all of these great answers on replay on our YouTube page. But I'm going to ask two questions that are in here, and then a third question is going to actually lead me into our awesome bonus content that we were talking about as we were planning for this. Somebody actually asked a question about it. So yes, I'll use that here in just a second. But we actually got some questions. There was one person that had kind of asked, hey, could you kindly go over those three particular items that the D&O coverage should cover for a board of directors?
Sure, absolutely. Do you want me to go back to the slide or just leave it where I am and just say it?
You can if you would like to, if that's easy for you, and for the people joining us, that probably would be a nice.
I mean, I know what they are, so it's okay. I hate to go back and forth and just see slides moving.
Whatever.
So what the three for general D&O, they don't usually cover discrimination cases. They do not cover fair housing cases, and they do not cover breach of contract cases. It's just like the standard. If you get a standard policy, they're not going to include it. But just for a small fee, this is like the trick of the trade is that if you ask for that, it's not a significant cost. It's like a very, very tiny increase. But if you don't know to ask for it, you just don't know. So that's my recommendation, is that when you look before your renewal, ask your provider, see if they are covered. If not, add them to that. And that's going to help prevent any sort of discrimination case that's not going to be, you're not going to be able to get a defense or indemnity provided because your D&O is not going to cover it. But if you know this and you have it added, it is going to cover it. And that will be great for you.
So leading into that question as well, which just as a quick review, and you can expound on this too as an attorney, but D&O coverage typically covers a board of directors and their actions and decisions while they are serving the community within a service capacity. And typically, most of those policies also not always, can cover committees and volunteers, correct? So like, hey, I've been I'm the pool committee chair and I'm responsible for making recommendations to the board. that would still kind of hopefully cover the association in the event that somebody didn't like my recommendation that I made, correct?
Correct. So one of the questions, if you are asking, if you're either new to the board or just want to make sure you're aware of this before your next renewal period, you want to ask that question. Typically, many D&O policies will actually also include past as well as current officers and directors, and it will usually include, and I will say usually, again, you want to double check for yourself, but a lot of times it will include committee members, current committee members that you have. So that is a way of also protecting not just the directors and officers, but a slightly larger circle. But definitely double check if you're already contacting the provider for these questions. These are, just follow up with that as well. But many policies do include the past as well as current officers and directors, and it will include committee members as well.
So the
You can
last question.
also, one other thing you can do is especially if you do certain volunteer activities and you might not have committees, you can secure like a volunteer workers' comp provision or policy. Very, very I don't want to say inexpensive, but it's not very expensive. And that's another way to kind of help provide for certain volunteers or committee members. But many D&O policies will include committees.
Good news is, friends, we have a whole class on this on our YouTube page. So if you've got more questions about what are the differences in some of those insurance policies, we've got you covered there. But lastly, staying in the vein of the liability, and I know you see this often, and as we've learned tonight, there's been just a rise. I mean, I was a little shocked by the number of harassment claims that you had shown from 2023 personally. But in that particular vein, when a board member makes a potential discriminatory comment, are they putting themselves in liability? And I think that would depend on what that comment is and if it's covered under the FHA, correct? Or if that individual possibly, maybe.
And we're saying that the board member is saying it to another third party or saying it at a meeting? How is it conveyed? Is it like on the Facebook's community page, or how
well,
which
and
that creates its own
those are great
layers of problems.
pre-qualifying. So I think the question being general as it is a very common question that we community managers get and receive from homeowners who are not volunteers, board members, right? And they may have concern about what they may hear a board member talk about or something of that regard. And so I feel like, or it could be a board member here that's just saying, hey, listen, we have a rogue board member that we cannot control what they say. And are they putting us in liability? Are we at liability because of potentially some of the communication that they have? That's what I would infer that this kind of comment or question is asking.
Sure. I mean, the brief answer is yes, it does increase your liability exposure, unfortunately. What I can do too, because this really segues very well into what we're going to do in the next segment, I'll make sure that I kind of come up with a scenario just like that, where we can walk through it and figure out what is needed to be done. So I'll use that as one of my hypotheticals and be able to like process that with everyone. But I would say that, I mean, yes, it does, but there are ways that we can try to combat it, and for the rest of the directors to help shield and protect them as well. There are steps to take for that.
And as Cindy is kind of very delicately dancing, a lot of these topics that we're talking about tonight have such specific instances, and it's typically more than one specific instance that has to be, not a lot of these topics are general. Now, obviously, when we're looking at potentially pool rules and those types of things, that is a little bit more generalized, but, discriminatory topics, things that potentially could impact insurance, what to do in those types of situations. Those are really on a per case basis that have to be investigated and specifically looked at with the particular association's attorney, not sweet and kind Cynthia, who is joining us tonight, that is just trying to encapsulate all the conversation in one. So I think that sounds like a great way to offer some additional context in class number 2. I will say this before we go to our last one. We did have one person ask, do lifeguards, and this is going back to pool rules and pool, and this is literally a whole class of its own as well, friends. Um, are pool lifeguards required to be at the pool at all times? That's a very interesting question. Not every pool has the ability or
Nope.
association has the ability to afford lifeguards.
No, and to be fair, the answer is no. There's no requirement that you have to have lifeguards or that they have to be there at all times. What is the requirement is that if the association wants to have lifeguards available, we need to make sure that they are on a tight schedule, that they follow the procedures, because what you're doing is you're creating an assurance in people
Mhm.
that they have this like kind of added layer of protection, because there's a lifeguard there, that we want to make sure that they are trained, that they are present, that they are timely. Those types of things, I'm thinking from like a premises liability standpoint of something tragic happening in the pool
Sure.
when under watch. But legally, no, there is no requirement. You can put up a sign and have rules that say swim at your own risk, and that is acceptable. Associations are not required to have lifeguards. But if you do, we want to make sure that we are keeping certain standards from a premises liability standpoint to help make sure that we don't get ourselves in trouble for having somebody not show up and then something bad happening. That's where we run in afoul and create some issues from a premises liability standpoint. But to answer your question, no, there's no law that requires lifeguards to be there. And there are many
Hmm.
communities that are not able to have lifeguards on a consistent or regular basis or at all.
Yep. And that's, again, friends, that's a whole different topic in and of itself right there, that we could truly spend an hour on, alone. So these have been excellent questions.
They
The
have,
question,
absolutely.
yeah, thank you. And this has been wonderful content. The question that we're going to lead into closing out tonight's, kind of, awesome first part course is, because all of you have taken such great, time and attention and effort into your association's, future and current status, we, have the privilege of actually offering some bonus content for those of you that sign up for our second class on February 20th that you see on the screen right now. Cindy has been so kind and generous. She is actually carving out a very special, we hope about 10 to 15-minute segment that is going to be sheer bonus content available for all of you. And this is going to be specifically related to FHA loan approvals, which is very different from fair housing requirements. This is now what we're going to be talking about with, can an association have, loan approval, and how long does that last? Can an individual home have, FHA loan approval, or do they have to do it? So Cindy is awesome and is going to provide this content for all of you because you guys are investing in your community. And so as exclusive bonus content, we are going to provide that for you, for the course next month. Again, for all of you, you definitely want to, if you enjoyed this course, we certainly want you to, sign up again for the February class and bring a friend. Don't forget, Heritage University is not exclusive to board members. Bring a homeowner, bring a future volunteer. If you are a community that is struggling to gain some, homeowner or volunteer involvement, this could be a really great opportunity to show and help out that you as a community are dedicated and engaged, just like, she shared that, DNO is not, required. Neither is board education, in the state of Georgia. And so all of this, we know you're doing on your free time and your spare time after you've had your full day of fun, whatever that might be, work or play. And so by continuing your efforts and your dedication to your community, we really, that's largely one of the biggest reasons why we offer Heritage University. The other great thing about Heritage University is you don't have to be a Heritage partner. We'd love for you to be a Heritage partner, but again, just like we talked about, we want to make sure that people have access to education, that you feel empowered, and that you're educated to be able to serve your community or potentially want to serve your community in the future. We just want to have these resources available to you. So again, join us on February 20th. Cindy is going to join us for the second part, and that is really going to be probably the most fun that we're going to talk about, because she's really going to be focusing on when does the board have to get involved, or when does the association have to get involved with FHA claims, with the homeowner instances. And then we're going to talk a little bit more. I think she had mentioned the liability aspects that potentially could be seen, especially with social media and all those other fun things. But we're going to talk about all of those fun things. And then for all of you, if this is your first time joining us, or if you are joining us on replay, we appreciate you. We have a great archive of previously hosted classes. So if you are not able to attend all of this, or you want to share this content with another board member or a homeowner or your brother's uncle, we would love for you to do that. And so in your resource email that you're going to receive within the next day or so, you will be able to sign up for that. The sign up's not going to be open just yet, so don't quote me on that one. But we will be doing the sign up for February's class here shortly. But you'll be able to give us some feedback on some future classes, and then we can certainly point you in the correct direction to where our YouTube page is located, where you can see the remainder of our class content. And then for all of you, again, who have joined us tonight, you will receive the full recording of this here in the next few days before we publish this personally, or I should say publicly, on our Facebook page. So, or our YouTube page, excuse me. We have a Facebook page too, but in any case, we appreciate all of your time and attention this evening, and we look forward to seeing you again in the audience really soon. Have a wonderful evening, everyone.
Bye.